All right, we're going to continue with chapter 10 and just kind of tying it back to the syllabus. Chapter 10 is the second part of class 9 and is dealing with beneficiaries and creditors' rights in trust property. And up to this point, we've talked about beneficiaries' rights in trust properties. So right now, we're going to talk more about creditors' rights in trust properties. Um, couple housekeeping announcements. So this is tonight's class is the one scheduled that we were going to have in person on October 28th because of the storm coming in. We're just doing it by video lecture, and I'm probably going to post, maybe two. It helps to post them in like 30-minute increments, so there'll be more than one video lecture posted for this class. Um, a couple people have asked me about the exam. I'll be talking more about it probably next week. I'm waiting on a little bit of feedback from the administration on format and how I administer it. I've got a way I want to do it, but I want to make sure that's okay. So I'll talk about that more next week. And also, some people had asked how to best prepare for the class. I think a good way to prepare is picking a handful of questions at the end of a chapter and working through them, either by yourself or in a group. Not all of them. There's a ton of them there, but picking a handful of them from the chapter and working through them is a good way to prepare for the exam, I think. That's probably most of the housekeeping. All right, continuing with Chapter 10, Rights of Creditors in Trust Property. So, as a recap, what we're really talking about here is a structure in which you've got a settlor has put property in trust for a beneficiary to use for a certain term. Let's say it's for life. It can be for life. It can be for a term of years. That part's not really important. But in our example, let's say it's for life. And the other important person in this arrangement is the trustee. And let's just call it Bank ABC. It's a bank as trustee of the trust. Settlers put the assets in for beneficiary for life. At the end of beneficiary's life, it's going to go to remainder beneficiaries, which could be children of the current beneficiary. It could be grandkids of the settlor. Doesn't necessarily matter for our example. So this is kind of the format we're working from. And we've talked a little bit about, what does this say? Does it say beneficiaries shall get distributions? Does it say they may get distributions? Does it use the ascertainable words, which tend to put more power in the beneficiary? Does it use less ascertainable standard words? And that's a term of art. I mean, you know what those are. Does it use less ascertainable standard words, which puts a distribution on the more discretionary end of the scale, which puts more power in the trustee? And they have more discretion on whether to make the distribution or not, and are oftentimes not second guessed by the court or reversed on the court, I guess, if you will. Um, and so that kind of builds up to their relationship to the trust. But what about creditors? What about people outside of the trust relationship that this beneficiary owes money to, and let's say legitimately owes money to? What are their rights in this trust property? What are the rights of the creditors of this person they owe money to? And now this person's money is here instead of being available to satisfy this person's creditors. What rights do that person's creditors have? And it all kind of depends on whose creditor it is. It's kind of the starting point for the analysis. Your book starts talking about creditors of a beneficiary who is not the settlor. So in a situation where this person and this person are not the same, we're going to talk about a little bit at the end of this class when they are the same. But in this case, the settlor is not the same person as the beneficiary. Page 341, if we've got mandatory distributions that come out of the trust, so the beneficiary shall receive income every year, interest, dividends, that kind of thing. The beneficiary shall receive 2% of the trust property every year as a required distribution. Can a creditor of the beneficiary attach those assets as a potential recovery form for the creditor. And um, a creditor can attach future distributions from the trust. So they can get a court order saying, um, as soon as a distribution comes out of the trust, we can attach it now and take it as soon as it gets out of the trust. We can have a current attachment of the future distribution now, and in order to satisfy the judgment. A creditor could do that unless there's something called a spendthrift clause in the trust. And that's a term of art. If there is a spendthrift clause in the trust, then a creditor cannot attach now future distributions. So what can they do? A creditor can wait until money lands in the hands of the beneficiary and then try to attach it. Um, it but and so but if there's not a spendthrift clause in the trust, a creditor can now go get an order attaching a current order attaching future distributions. So, um, what is a spendthrift clause? Because it's pretty important. It's a really important clause in trust, and you really won't find many trusts without one anymore. Um, and so I'm going to go a little bit out of order. Yeah. So on page 342, they give you an example of a spendthrift clause. A spendthrift clause is basically a provision in the trust that says really two things. One is the beneficiary cannot pledge trust assets as his or her credit source, as collateral for the purchase of a home, for the purchase of a car, for anything. The beneficiary cannot pledge assets until they receive them. That's one thing it says. The other thing it says is, and a creditor cannot rely on trust assets to satisfy a debt of the beneficiary until the beneficiary receives them. And if a creditor does rely on trust assets as security for a debt, the creditor really does it at their own peril. Um, and that's really a form of the settlor having the freedom to do with his or her property as he or she chooses, basically. I mean, we've got some limits to that, but basically, a settlor can put those rules on a trust that says, beneficiary, you can't pledge this stuff until you get it. And creditor, this is my stuff. You don't get it either until the beneficiary puts it in their name. Then you can rely on it as the beneficiary's asset, and the beneficiary can pledge it as their asset for collateral for a debt or that sort of thing. So a spendthrift clause addresses those two things. And you can see page 342 at the bottom, there's an example spendthrift clause. So read it and make sure that makes sense to you, to what I just explained. Going back to page 341, when you've got a mandatory distribution out of a trust, the beneficiary shall receive income every year. The beneficiary shall get 2% of the trust property every year. If you don't have a spendthrift, the creditor can get a current attachment of future distributions. Doesn't mean they get the money now, but they get a current attachment of future distributions. The spendthrift clause prevents the creditor from having anything current against the trust. They can do whatever they want against the beneficiary once the beneficiary gets the assets. Discretionary distributions, what do you do there? A creditor is extremely unlikely to be able to attach anything related to the beneficiary's debts if all distributions out of this are discretionary in the hands of the trustee. Um, a court is not going to force a discretionary distribution out of the trust for the benefit of the creditor, and so a creditor is not in a good position. The UPC, UTC, not the UPC, Uniform Trust Code, applies some super preferred creditor rights in some cases. Section 504C, fairly controversial section. Not all states adopt 504, and if they do, they curtail it pretty significantly. But 504 says there are some preferred creditors, child, spouse, or former spouse of the beneficiary with an order of support. And so in those cases, under the UTC, they might be able to get something out of even a discretionary trust for that super preferred creditor level under the UTC. But please know that I think your book even says um, some states adopted the UTC, did not adopt 504C or have modified it significantly. And that's a very true statement. Um, how does a creditor of a beneficiary get paid? From a logistical standpoint, first the creditor needs to get a judgment recognizing its debt, and then it needs to try to enforce the judgment, get a sheriff to try to get him to enforce the judgment. And that's how this comes up. Someone's trying to enforce the existing court judgment against the trust. And it matters whether it's mandatory, it matters whether it's discretionary, and it matters whether there's a spendthrift clause in there. So that's the beneficiary. The settlor, they kind of do this a little bit out of order. Page 342, there's a section on existing creditors of the settlor. And a settlor, a grantor, is allowed to put their assets in trust for somebody else. They're allowed to part with them and let somebody else benefit from them, as this diagram kind of highlights. What do you do with a settlor that has existing creditors that they owe the money to? So now you've got a balance. Do the creditors get that money, or does the beneficiary of the trust get that money? And a settlor who has existing creditors, if they try to move assets away from them to other people to benefit, it can be considered a fraudulent conveyance. And the settlor can be liable continue to be liable for his or her own debt, but the transferee can also be liable for the debt in the case of a fraudulent transfer. So that's a little different than the creditor of the beneficiary going after it, but there is a potential to get, for a creditor to get the assets if it's a creditor of the settlor and there's been a fraudulent conveyance to the trust. We've talked about spendthrift clauses. Do read through that on page 342. Sometimes there's some exceptions to spendthrift clauses based on state law. 504C being an example of that, if your state's adopted that. The Shelley versus Shelley case is kind of interesting. In the Shelley versus Shelley case, we've got a trust that has a spendthrift clause, and they quote the spendthrift clause on page 344. And we've got two ex-wives and kids from both marriages. Shelley apparently was not the greatest guy, and there's assets in trust. Dad put assets in trust for son, for the son, I think it's his lifetime, and it distributes income, interest, dividends, that kind of thing. And there's also trust principal that can be distributed for, let's see what it says. Income is paid to him in intervals not less than 3 months apart. And then the trustee can distribute principal in the trustee's discretion. And the trustee can make distributions to my son or his children in the case of an emergency whereby unusual and extraordinary expenses are necessary for the proper support and care of my son or the children. So the children are also, kind of secondary beneficiaries, but they're beneficiaries in the case of an emergency. So son gets married, has 2 kids, divorces his wife, gets married again. I think he has 2 kids with the second wife too. and then divorces her too. And first marriage, I don't think the wife was awarded alimony, but the kids were awarded child support. Second marriage, I think she got alimony and the kids got child support again. The question is, can the ex-wives and the kids, go after, of course, the son isn't paying either of those things. He's not paying the alimony to the second wife or the child support to the kids. Can they go after the trust assets for those obligations? And this trust contains a spendthrift. And they quoted on page 344, about middle of the page, beneficiaries hereby restrained from alienating, anticipating, encumbering, or in any manner assigning his or her interest or estate, either in principal or income, and is without power to do so. So the settlor is preventing this, and that's kind of okay. I mean, this is the settler's money. He gets to make some of the rules of how it's going to be held for the beneficiary. And one of those rules that he decided to get to make was, this is for my son and it's not for his creditors. So there's nothing inherently wrong with that. It just turns out son's not a great guy in this case. So the court goes through and tries to figure out, I think trial court entered an order saying the accrued income of the trust could be used for the plaintiff, one of the ex-wives, and she could even get into corpus if the income wasn't enough. And the children could also have corpus to satisfy their obligations. This court says that the beneficiary, so they're looking at two pieces of what comes out of this trust. They're looking at the income and they're looking at the principal, because those are the two things leaving the trust. And the court says that the income of the trust is, subject to claims of alimony and to the claims of support. Let's see. And the claimants can only get that much of the income that the trial court deems reasonable under the circumstances, having in mind respective needs of husband and wife, needs of children, amounts of the trust income, etc. And the question of the claimant's rights to reach corpus, they got to look at some other things. It says the ex-wives cannot reach the corpus because the beneficiary has no realizable interest in it. It is discretionary as to the son, and he can't force a distribution out of it. So the ex-wives can't get there. But as it relates to the kids, it says the kids can, claims of the kids can reach the corpus or the principal of the trust. And the way they got there was because the trust speaks of the kids. The trust includes the kids as potential beneficiary. Bottom of page 346. The kids are named as beneficiaries of the trust and need not claim derivatively through their father. They are entitled to the share of the corpus. If in the trustee's discretion it's determined that an emergency exists, we construe the clause to include the circumstances involved here, where the children are deserted by their father and are in need of support. They say that rises to the level of an emergency. So that's how they end up getting corpus to the kids, but they don't end up getting corpus to the wives, the ex-wives, because they're definitely not beneficiaries of the corpus, which is fully discretionary. So it, who can get to it depends on the type of distribution it is. This was mandatory, this was this was discretionary, and who's entitled to the distribution. And that is a 1960 case, so it's a little bit older. And then your book talks about creditors of a beneficiary who is the settlor. So kind of switching gears from this guy back to this guy. We've talked about revocable trusts in here as kind of a will substitute. Revocable trusts do nothing for creditor protection. They're just an alter ego of the settlor. And nothing, because the settlor can revoke it, the settlor can get assets out of it, it's for the settlor. So there's nothing creditor protection wise about a revocable trust. It's the equivalent of full ownership of the assets as far as your creditors go. If you have an irrevocable trust, kind of like you did here, settlor put it in for beneficiary, then there's two types of revocable trusts. There's one that settlor puts it in for somebody else, and there also is an irrevocable trust format where settlor puts it in for himself or herself as beneficiary. When the settlor puts it in for the benefit of someone else, but for a fraudulent conveyance talked about on page 342, the settlor's creditors can't get to it because the settlor doesn't own it anymore. The settlor has parted ways with it. It is now in a trust for somebody else, and the settlor's creditors can't get to it unless it was, a fraudulent conveyance and the settlor owed money to the creditor at the time they made the transfer to the trust. But what if you have a trust where the settlor puts money in for settlor's benefit for life, and then goes on to remainder beneficiaries. And this is irrevocable. And we have a trustee over here who is not settlor, who is bank. So when settlor owned the assets, he fully controlled them. He puts them in the trust, and this is 100% discretionary distributions, 100% discretionary of whether anything comes out of the trust. If it does, it benefits settlor. And the person who decides whether anything comes out is trustee, which is bank, which is not settlor. So does settlor still own something? Does settlor still kind of own this property that he used to, and can settlor's creditors get to it? An argument is no, creditors shouldn't get to it because settlor doesn't control whether money's coming out or not. An argument exists that yes, settlor's creditors should get to it because it was settlor's assets. We can't let a settlor defraud his or her own creditors by voluntarily moving their own assets into a trust that still benefits themselves. That would be a fraud on creditors and not a good policy to allow. And the states kind of come down on both sides of that. 349, this concept called a domestic asset protection trust, DAPT. Some states, and it's a minority of them, but it's kind of a growing list. Some states say a settlor can put assets in a trust for him or herself, an irrevocable trust for him or herself, if the settlor is not trustee and distributions are fully discretionary, thereby saying the settlor doesn't really control those assets anymore. Some states say you can do that and it's protected from your creditors. Other states say, no, you can never have what's called a self-settled trust for your own benefit and escape your creditors. No self-settled trust. Alabama is one of those states where you cannot put your own assets in trust, no matter whether you're trustee or not, no matter whether it's discretionary or not, and avoid your creditors. That's the majority position on most states. But Delaware, Nevada, Tennessee's new to the list. Delaware, Nevada, Tennessee, I don't know if it's both Dakotas or just South Dakota, Wyoming. They probably give you a list in your book. Alaska. They have changed their legislation to allow people to set up trusts like this. And it's a little bit of a cottage industry. And so the theory is I have a client that might be in a high risk business, real estate developer, doctor, lawyer, that's got some assets that they want to protect if they get a creditor against them, if they get sued someday. So they might move $1 million of assets into this trust, but they're trying to set up kind of a rainy day fund if they get sued and lose everything else. And this is what I'll live on. So they need to be beneficiary. But to go into this transaction, that client has to realize that they don't control these assets anymore because they're merely a discretionary beneficiary at the control of somebody else. So you got to be okay with that. And if you need the assets someday, you got to be able to go to the trustee and say, here's why I need them. I've run out of everything else and I've got bills to pay. And the trustee, might agree that a distribution needs to come out and probably would agree that a distribution needs to come out. But you got to be the type of person that's okay not being in control of the assets anymore. There are ways to build in some backdoor control, which are kind of beyond the scope of this class. Um, so there are ways not to lose 100% of control, but you will lose um, substantive control of the assets. And and that's kind of your rainy day fund. That's your asset protected assets. I mean, your asset protection trust that's out there if you lose everything else. So if you do get sued, if this beneficiary does get sued, the settlor who is the beneficiary, and a creditor gets a judgment against them, and let's say this happened in Alabama, let's say it was a real estate developer that gets sued and there's a judgment, he loses and has a judgment against him, but he has set up this trust in one of the states that allow it, Delaware, Nevada, Alaska. The way you have a trust in another state is you have to have a trustee in that state. So he's gone to a bank in Delaware, in one of the states that allows it, and hired a Delaware trustee to manage his Delaware trust that owns $1 million of cash assets or stocks and bonds. The Alabama creditor who won the lawsuit against him now, so you've got a plaintiff from Alabama where the cause of action was. They go to enforce their judgment to the Delaware trustee, and the Delaware trustee says, no, our law says, the law the trust was formed under, says that this is protected from your creditor. So, Alabama judgment creditor, we're sorry, you're out of luck. We're not going to release the funds to satisfy your Alabama judgment. What you inherently have is a conflict of state laws. And so there's a constitutional argument whether this works, and that is the full faith and credit clause. Are we respecting each other's state laws? And so that's the asterisk with this type of transaction is it it probably works and people do it all the time. But if push comes to shove in one of these things, the constitutional question is going to get asked someday and decided of whether these things violate the full faith and credit clause of the Constitution. So when we do them for folks, we have to tell them this is a good technique, and it will probably and it helps prevent creditors from getting your assets. But there's a chance that there could be a constitutional issue here, and you might lose. Um, but people do them all the time, and so far, hopefully you don't have a judgment creditor. But if you do, it'll at a minimum, it's going to make it difficult to get to the assets because they're going to say no, and they're going to make you fight for them, which means you've got to now bring your constitutional claim to try to get it, and that's litigation. That's years and years of court time. Um, some clients take this is the D in this is domestic asset protection trust, meaning within the U.S. Some clients take them offshore and have an offshore asset protection trust and go to a country where this whole setup where the country is not going to respect the U.S. judgment against the assets. And there's certain havens that do this, the Cayman Islands, the Cook Islands, a couple different places. So if you're a client that's comfortable moving your assets to one of those countries and having a trustee in one of those countries, then who cares if it's unconstitutional because they're not part of the U.S., so they don't have to respect our laws. And so those are deemed to be a little more protective than a domestic asset protection trust. But, it's not all good news. You got to be comfortable moving $1 million to the Cook Islands and comfortable with their government setup that you can get it back if you need it. You got to be comfortable moving $1 million to the Cayman Islands when you're not there, and you hope you can get it back if you ever need it. So it takes the right client for this to work, but there are people that do it all the time. They're not. It's not an inexpensive transaction at all. You're talking international law. You got to hire a trustee in one of these locations, whether it's domestic or foreign. You got to hire a trustee in one of these places that allow it. That's not inexpensive at all. And I kind of, I used $1 million. You really wouldn't do this for $1 million. You would do it I mean, this is my view. There's no law that says you can't do it for $1 million, but in my view, you wouldn't do it for several million because of the cost involved. You got to make it worth it, um, to make it worth it, because you got to pay this trustee every year to be your trustee. So you got to make it worth your while to do it. All right. So that's the rest of chapter 10. We're going to be back in a minute with a video starting on chapter 11, fiduciary duties in trusts.